Hello, I'm attorney Benjamin Henry, and I'm going to speak briefly about a Chapter 13 bankruptcy. Chapter 13 bankruptcies are a little bit different than Chapter 7s, where someone has all of their debts discharged in a matter of months as they proceed through the Chapter 7 process. A Chapter 13 bankruptcy is more of a reorganization of a person's finances. A Chapter 13 bankruptcy is typically used for a client who may have too many assets that they don't want to get rid of in a Chapter 7. It would also be used for someone who has filed a Chapter 7 within the last 8 years and cannot file another Chapter 7. You are allowed to file a Chapter 13 within 4 years of filing a Chapter 7. So it gives someone who has maybe gotten into another sticky situation an opportunity to help themselves out again. In a Chapter 13, again, we look at all of the liabilities a person may have, all of the debts that that person has, and we reveal these debts to the bankruptcy court, and we put those creditors on notice. And the main thing that happens in a Chapter 13 is that the debtor submits to the bankruptcy court a repayment plan. Because in a Chapter 13, unlike a Chapter 7 where your debts are discharged and there's no personal liability, in a Chapter 13 you are proposing to your creditors and to the bankruptcy court to repay at least a portion of the debts that are owed to them. Now, it won't often be the full amount owed, and it almost never is, but at the end of a Chapter 13, again, after having paid for either 3 or 5 years on a plan that a person has submitted to the bankruptcy court and that the creditors and the bankruptcy court have submitted, at the end of the 3 or 5 year plan, a person's debts are again discharged, meaning that that person no longer has personal responsibility for the debts that were listed in the Chapter 13. If you'd like any more information about filing a Chapter 13, please contact our office for your free consultation.